A new immigration law has officially passed today, January 23, 2026, and it's already creating massive waves throughout the immigrant community. If you're holding a green card, or you know someone who does, what I'm about to share could directly impact your status, your travel plans, and your pathway to citizenship. This isn't speculation. This isn't a proposal. This law has been passed, and the changes will take effect sooner than most people expect. Stay with me for the next several minutes because understanding this new law could mean the difference between protecting your status and facing serious complications. If you're new here, welcome. I'm your source for verified, no-nonsense immigration updates. Before we get into the specifics of this new law, let's establish some critical context. A green card, officially called a lawful permanent resident card, grants you the right to live and work permanently in the United States. It's one of the most valuable immigration statuses in the world. But here's what many people don't realize. Your green card comes with ongoing responsibilities, and those responsibilities can change when new laws are passed. U.S. immigration law doesn't stay frozen in time. Congress, federal agencies like USCIS and DHS, and executive orders regularly update policies. Some changes are minor. Others, like what we're discussing today, are significant enough to require immediate attention from millions of green card holders. So why is this January 2026 law different? 3 reasons. First, it changes compliance requirements that have been standard for decades. Second, it introduces new verification procedures that affect international travel and re-entry. Third, it impacts pending naturalization applications in ways that weren't anticipated. The broader 2026 immigration environment has been focused on modernization, enforcement, and what policymakers call status integrity. This law is part of that larger shift. Now, let's get into what actually changed. The law passed today is officially titled the Lawful Permanent Residence Integrity and Verification Act of 2026. It's dense, it's technical, but I'm going to break it down into 4 major areas that affect you. First key change: eligibility and status rules. Under the new law, green card holders must now verify their permanent resident status through a federal database every 24 months. This is completely new. Previously, you'd update your address when you moved, and that was generally it, unless you were traveling or applying for citizenship. Now, you'll receive a notification, likely through mail and email, requiring you to confirm basic information: your current address, employment status, and that you haven't abandoned your residency. This verification takes about 15 minutes online, but failure to complete it within 60 days of notification can result in status review proceedings. Here's a realistic example. Let's say Maria has held her green card since 2022. Under the old rules, as long as she lived in the U.S. and didn't break any laws, she was fine. Under this new law, when she receives her 24-month verification notice in 2027, she must log into the new USCIS portal, confirm her details, and submit the verification. It's not optional. Second key change: travel and re-entry considerations. This is where green card holders are expressing the most concern. The new law states that any green card holder who spends more than 180 days outside the United States in a single 12-month period will be subject to enhanced screening upon re-entry. This doesn't mean you'll be denied entry automatically, but you'll need to demonstrate that you haven't abandoned your U.S. residency. What does enhanced screening mean? It means secondary inspection, additional questions about your ties to the United States, like employment, property ownership, family connections, and, potentially, delayed processing times. Previously, the informal rule was that absences of more than 6 months raised questions, and absences over 1 year risked abandonment. This new law codifies stricter scrutiny starting at the 6-month mark. Example: Raj is a software engineer with a green card. His company sends him to their India office for 7 months. Under the old system, he might face some questions, but would likely be fine. Under the new law, he's now required to carry documentation proving his intent to maintain U.S. residency, lease agreements, employment contracts, tax returns, family evidence. He may also need to file a special form before traveling if he knows he'll be gone more than 180 days. Third key change: compliance and reporting expectations. The third major change introduces annual reporting for green card holders in specific categories. Those who hold green cards through employment-based sponsorship, those who obtained status through investment programs, EB-5, those with conditional permanent residence status. If you fall into these categories, you'll now need to file a brief annual report confirming your employment status, business activity, or marital status for marriage-based conditional residence. This report is separate from your taxes and separate from the 24-month verification. The stated purpose, according to the law's sponsors, to prevent fraud and ensure that green cards obtained through specific pathways are being used as intended. Fourth key change: impact on pending or future applications. Here's something that caught many immigration attorneys off guard. The new law extends the continuous residence review period for naturalization applications. Previously, USCIS examined the 5 years, or 3 years for spouses of U.S. citizens, immediately before you applied for citizenship. The new law allows USCIS to review your entire period of permanent residence when evaluating whether you maintained continuous residence and physical presence. What this means, if you've had your green card for 8 years and you're now applying for citizenship, USCIS can look back at all 8 years for any extended absences or compliance issues, not just the most recent 5. This doesn't change the 5-year or 3-year requirement itself, but it dramatically increases scrutiny for applicants with complicated travel histories. So why are people calling this law shocking? Let me be clear. This law does not revoke anyone's green card automatically. It does not create new deportation categories. It does not ban travel. But it does create new obligations and consequences that many green card holders weren't prepared for. The shock comes from 3 main factors. First, the lack of widespread advanced notice. While this bill was working through Congress, it didn't receive major media coverage until this week. Many green card holders are learning about these changes only now that the law has passed. Second, the retroactive review provision. People who traveled extensively years ago thinking they were in compliance may now face questions during their naturalization interviews about trips they took 5, 6, or 7 years ago. Third, the new administrative burden, the 24-month verification system, the annual reports for certain categories, the enhanced documentation requirements for international travel. These all create new responsibilities that require time, attention, and organization. Now let's address some common fears versus the reality. Fear: I'll lose my green card if I travel outside the U.S. Reality: you can still travel. The law simply requires better documentation and awareness of time spent abroad. Fear: I'll be deported if I miss a verification deadline. Reality: missing a verification triggers a review process, not immediate deportation. You'll receive multiple notices and an opportunity to comply. However, ignoring it completely can lead to status complications. Fear: this law targets specific nationalities or ethnicities. Reality: the law applies uniformly to all green card holders regardless of country of origin. Bottom line: this law increases accountability and documentation requirements. If you've been maintaining genuine ties to the United States and following existing rules, you're not in immediate danger. But ignorance of these new requirements is a risk. Immigration attorneys across the country have been responding to this law since it passed earlier today. Sarah Mitchell, a managing attorney at a prominent immigration law firm in New York, stated, "This law represents the most significant change to green card holder obligations in over 15 years. Our advice to clients is simple: document everything, maintain clear ties to the United States, and don't assume the old informal rules still apply." Policy analysts have offered mixed perspectives. The Migration Policy Institute noted that the law reflects a broader trend toward digital verification systems and enhanced immigration status monitoring. They've pointed out that similar systems exist in Canada, Australia, and several European countries. However, immigrant advocacy organizations have expressed concern about the potential burden on elderly green card holders, those with limited English proficiency, and people in rural areas with limited internet access. They're calling for robust outreach and support services to help people comply. The Department of Homeland Security released a statement this afternoon indicating that the 24-month verification system will be phased in over the next 6 months. They've committed to multi-language support for the verification portal, phone assistance for those without internet access, clear, simple instructions mailed to every registered green card holder, a 90-day grace period for the first verification cycle. USCIS has announced they'll be launching a dedicated webpage and helpline specifically for questions about the new law. They've emphasized that their goal is compliance, not punishment, and that they'll work with green card holders who make good faith efforts to meet the new requirements. Immigration law professors have noted an important distinction. This law doesn't change the fundamental nature of permanent residence. You're still a permanent resident with the same core rights. What's changed is the administrative framework around maintaining and proving that status. The consensus among experts: stay informed, stay organized, and take these new requirements seriously. But don't panic. All right, let's get practical. Here's your step-by-step guide for what to do right now. Step 1. Stay informed through official channels. Your first priority is to bookmark and monitor these official websites. USCIS.gov, the primary source for all policy updates. DH.gov, broader immigration policy announcements. Travel. State.gov, for travel-related guidance. Do not rely solely on social media forums or unofficial sources. Immigration misinformation spreads quickly, and acting on bad information can have serious consequences. Sign up for USCIS email alerts if you haven't already. They'll notify you of major policy changes and when the verification system launches. Step 2. Review your current status and history. Pull out your green card and check your current address on file with USCIS. Update it if you've moved your expiration date. Green cards typically expire every 10 years. Any upcoming international travel plans. Next, create a travel log. Go through your passport stamps and any records you have of international trips. Note: dates of departure and return. Total days outside the U.S. purpose of travel. This will be invaluable if you're interviewed during re-entry or when applying for naturalization. Step 3. Gather and organize documentation. Start assembling documents that prove your ties to the United States. For everyone, lease agreements or mortgage documents, utility bills, bank statements showing U.S. accounts, tax returns, driver's license, or state ID for employment-based green card holders, current employment verification letters, pay stubs, W-2 forms. For those planning extended travel, letter from employer explaining work assignment, property ownership documents, family ties documentation, spouse, children in U.S. schools, etc. Keep digital copies and physical copies in an organized folder. Step 4. Monitor for your verification notice. Based on DHS statements, the 24-month verification notices will start going out within 6 months. Make sure your mailing address with USCIS is current. You check your email, including spam folders, regularly. You respond within the 60-day window when you receive your notice. Set calendar reminders for yourself every 24 months from your green card approval date as a backup. Step 5. Consider professional guidance for complex situations. You may want to consult an immigration attorney if you have extensive international travel in your history, you're planning to be outside the U.S. for more than 6 months, you're in the middle of a naturalization application, you've had any compliance issues in the past, you fall into the categories requiring annual reporting. This video is educational, not legal advice. An attorney can review your specific situation and provide personalized guidance. Step 6. Prepare for international travel. If you plan to travel internationally, keep a folder with all your U.S. ties documentation, file form I-131, application for travel document. If planning absences over 180 days, carry evidence of your return plans, return ticket, ongoing employment, etc. Allow extra time at re-entry for potential secondary screening. Let's talk about consequences, because understanding the stakes helps you take this seriously without panicking. If you miss the 24-month verification, the first thing that happens is you'll receive a second notice, then a third. USCIS has stated they'll make multiple attempts to contact you before taking any action. If you continue to ignore the verification after multiple notices, USCIS may place your case into review status, require an in-person interview, issue a notice to appear, NTA, for an immigration hearing in extreme cases of non-response. This is a graduated process. One missed notice with a reasonable explanation won't cost you your green card. Systematic noncompliance over months or years is what creates serious problems. If you fail to document extended travel properly, when you return to the United States after more than 180 days abroad without proper documentation, you may face extensive secondary screening. Be asked to sign Form I-407, abandoning your green card, which you can refuse. Have your case referred to an immigration judge to determine if you've abandoned your residence. The key word here is abandoned. U.S. immigration law has always required green card holders to maintain the U.S. as their primary residence. This law simply makes enforcement more systematic. If you're in a reporting category and don't file annual reports, failure to file required annual reports can result in delays in naturalization processing, denial of naturalization applications. In cases of investment-based green cards, potential revocation proceedings if fraud is suspected. In very serious cases involving fraud or intentional noncompliance, consequences can include removal proceedings, bars to future immigration benefits. In extreme cases, criminal penalties for immigration fraud, travel consequences. If your status is under review or you have unresolved compliance issues, you may be unable to re-enter the U.S. after international travel. You could be detained at the port of entry while your case is resolved. Future consequences if your green card is lost. Visa applications could be denied. Administrative consequences. Employment verification issues. I-9 problems. Inability to renew your green card. Denial of professional licenses that require immigration status verification. Problems accessing benefits you're eligible for. Here's the important takeaway. These consequences are for people who ignore the law, not for people who make good faith efforts to comply. If you receive a notice, respond. If you make a mistake, correct it. If you're unsure, ask for help. USCIS has emphasized they're not looking to trap people or create gotcha situations. They want compliance, and they'll work with people who are trying to follow the rules. To understand where this law came from, we need to look at the broader context of U.S. immigration policy in 2026. Over the past several years, there's been bipartisan interest in what policymakers call immigration system modernization. This includes digitizing paper-based processes, implementing verification systems to reduce fraud, creating more accountability across all immigration categories, addressing backlogs, and processing delays. This law is part of that larger modernization effort. The 2026 policy environment. The current administration has prioritized what they call status integrity, the idea that immigration statuses should mean what they say they mean. If you're a permanent resident, you should actually reside permanently in the United States. If you're here on a work visa, you should actually be working in the occupation specified. This isn't just rhetoric. Department of Homeland Security data from 2024-2025 showed that approximately 12–15% of green card holders could not be located at their address of record when notices were sent. Additionally, there were documented cases of people maintaining green cards while living primarily outside the United States for years. This isn't the first time green card requirements have been tightened. Similar changes occurred after September 11, 2001, when security concerns drove new documentation requirements. In 1996, with the Illegal Immigration Reform and Immigrant Responsibility Act in the 1950s, when registration and reporting requirements were first established. Each generation of immigration law tends to add layers of accountability and verification. Why now specifically? 3 factors came together in late 2025 and early 2026. First, technology finally caught up. The USCIS modernization of their systems over the past few years created the infrastructure needed for digital verification at scale. Second, there was unusual bipartisan support. Both parties agreed that the immigration system needed better tracking mechanisms, though they disagreed on many other aspects of immigration policy. Third, the naturalization backlog created pressure. With record numbers of green card holders applying for citizenship, USCIS needed better tools to verify continuous residence claims quickly and accurately. According to available data for Entry Status USA, There are approximately 13.3 million green card holders in the United States. As of 2025, naturalization applications have increased by 23% over the past 3 years. Estimated processing times for citizenship have grown from 8 months to 14 to 16 months. Fraud detection cases involving permanent residents have increased by 18% since 2022. These trends created political will for systematic reform. What this means for future policy. This law likely signals the direction of future immigration policy: more digital, more verification-based, more documentation-focused. We may see similar systems rolled out for other immigration categories in the coming years. For green card holders, the message is clear. The informal honor system era of permanent residence is over. The new era is about active compliance and ongoing verification. Let's bring this all together. Today, January 23, 2026, a new U.S. immigration law passed that fundamentally changes how green card holders interact with the immigration system. The core changes: mandatory verification every 24 months, enhanced scrutiny for travel exceeding 180 days, new reporting requirements for specific categories, extended review periods for naturalization applications. Why it matters. These aren't minor administrative tweaks. These are structural changes that require you to be more organized, more documented, and more aware of your obligations as a permanent resident. What you should feel: not panic, not fear, but awareness and respect for these new requirements. If you've been maintaining genuine ties to the United States, if you live here, work here, pay taxes here, and consider this your home, you're going to be fine. But you need to take these administrative requirements seriously. Your immediate action items: bookmark USCIS.gov and monitor for updates. Verify your address is current with USCIS. Start organizing your documentation. Create a travel log of international trips. Set calendar reminders for verification periods. Plan ahead for any international travel. Know when to seek professional legal guidance. This is where you come in. If this video helped you understand this new law, please hit that like button. It helps more green card holders find this information. Subscribe to this channel and turn on notifications, because I'll be following this story as USCIS releases implementation details, as the verification system launches, and as we learn how this law affects real people in real situations. Share this video with anyone you know who holds a green card. The biggest risk right now is ignorance. The more people who understand these changes, the better prepared our community will be. Drop a comment below if you have questions. I read them all, and I'll make follow-up videos addressing the most common concerns. Final thought: your green card represents opportunity, security, and your future in the United States. Protecting it doesn't require perfection. It requires awareness, organization, and a commitment to meeting your obligations. This law might feel overwhelming right now, but remember, millions of green card holders will navigate this successfully. You can be one of them. Stay informed, stay compliant, stay protected. I'll see you in the next update.